Okay, good. Let's start. Welcome to this session, everyone. I see we are at least 9 participants, so there are enough people to ask you questions. So far, we have one speaker. It's Bergman from the Ludwig Maximilian University in Munich, and he is going to speak about church law without dark sides. With a question mark, I'm not so sure that that could be answered in the negative, because if I remember church law, there are a lot of dark sides. Comparing Catholic and Protestant positions in Germany. And I must tell you, when I went the first time to Germany and they asked me, what religion are you? And I said Christian, because the divide between Catholic and Protestant isn't that huge in South Africa. And they said, no, are you, you must say what type of Christian you are. So I said Protestant. And they just said, no, you either Catholic or Evangelisch. So they didn't know at that moment what Protestant meant. So I'm a Protestant Christian. You've got the floor. Thank you, Birgit.
Thank you very much. Good evening, ladies and gentlemen. I would like to thank the organizers of this conference for the opportunity to hold this lecture. And especially I would like to thank Professor Rautenbach for her chairing these panels and all those listening to my presentation. First of all, I would like to share the screen. Okay, you have deactivated the screen sharing. Could you please open that?
I've opened it.
Oh, now it's working, yes. Okay. Can you see?
Yes.
Okay. Very good. So, but that's not the first. Let's start with the first slide. Yeah. My topic is church law without dark sides, comparing Catholic and Protestant positions. There can not, law has bright and dark sides. There can be no doubt about that. Religions are also aware of this, which is why they have different attitudes towards law. Yet most religions also have a legal dimension themselves. Many have their own internal law. But do the dark sides of law have a place at all within the brightness of religion? At the beginning of the 20th century, the German legal historian Rudolf Sohm observed the contradiction between the darkness of law and the brightness of the church. His extreme position triggered numerous reactions in Germany, which attempted to contest him. Approaches that attempted to place church law on a theological basis are of special importance. My contribution will present 2 Protestant and 2 Catholic approaches. The method is both interdisciplinary and comparative. Interdisciplinary because it combines theology and jurisprudence. Comparative because it juxtaposes Catholic and Protestant church law. An overview of non-Christian religions will serve as a starting point. A comparison between the internal laws of different religions reveals contradicting conceptions of law. In Judaism and Islam, law is for the most part perceived positively. Judaism is a religion in which the law plays a central role. Part of the essential content of the Sinai covenant, which has fundamental significance, is that the people of Israel has committed itself to a considerable quantity of legal norms. In the book of Deuteronomy, we read, "What great nation has statutes and ordinances that are as just as this whole law, which I am setting before you today?" Judaism is a religion of practice, which is all about correct behavior that is conducted in accordance with the law. As far as Islam is concerned, the Sunni branch in particular has the reputation of being a strictly law-focused tradition. In contrast, Taoism and Confucianism regarded written law as a violation of the social order, provoking disharmony. Taoism takes a critical stance towards the law because laws simply serve interest groups, and an increase of laws lead only to an increase in transgressions. The Confucian concept of law is that of Li. This designates the totality of all forms of intercourse and behavior which make for a good person and an intact social order. It is based on the natural order. For Confucianism, court cases are an evil, because it is better to make compromises than to insist on one's rights. It is directly opposed to the concept of law of Chinese legalism, the so-called Fa. According to this, law is what is created as law by the ruler. It is accompanied by official codes and centralized bureaucracy. The legalists insisted on the complete equality of all people before the Fa, as opposed to the Confucian acknowledgement of the inequality of people. While Confucianism saw law itself as a violation of the social order, legalism aimed consciously to destroy and remake the old social order. But let us turn now to my main topic, which is the Christian church law. This cannot be discussed without shedding light on the biblical and theological view of law in Christianity. From its beginning, Christianity has had an ambivalent attitude towards the law. Redemption is certainly not expected as a result of compliance with the laws. A certain degree of skepticism towards the law is evident in some passages of the New Testament. The biblical statements, however, are by no means one-dimensional. Jesus Christ emphasized that he had not come to abolish the law, but to fulfill it. Paul placed grace before law, while creating the first church orders for his congregations. Steps towards a legal order for the primitive Jerusalem church and the congregations founded by Paul are found already in the New Testament. As early in the first centuries, collections of laws, such as the Didache and the Apostolic Constitutions, came into being. Let us now turn to the Middle Ages. Great figures of the Middle Ages had a positive view of law, especially canon law, which was associated with justice. Gratian, the outstanding canonist of the 12th century, handed down a dictum of Isidore of Seville: law is so called because it is just. Thomas Aquinas, the most influential theologian of the 13th century, regards law as an ordinance of reason for the common good. He concludes that law is the object of justice. The roots of this concept of law lie in Greek philosophy and Roman law. For Aristotle, everything legal in the broadest sense is something just. And the important Roman jurist Alpian described law as the art of goodness and equity. By justice, he understood the constant and perpetual disposition granting to each person his right. On the other hand, spiritualist tendencies, which have always existed within Christianity, have called canon law into question. Examples are Joachim of Fiore in the 12th century and Marsilius of Padua in the 14th century. Similar ideas resurfaced around the Reformation, for example, with Thomas Müntzer. This leads us to the period of Reformation. Martin Luther burned the medieval canon law in Wittenberg in 1520. However, Melanchthon published a selection from the Decretum Gratiani as early as in 1530, which found Luther's sympathy and served as an ecclesiastical order for the early evangelical parishes and schools. Evangelical in the sense of evangelisch, as Professor Rautenbach already said. In accordance with Protestant ecclesiology, the hidden church of faith is not subject to regulation in law. Only historically concrete churches can therefore have a legal constitution. The content of church law was evaluated from the point of view of functionality. At the beginning of the 20th century, the Protestant legal historian Rudolf Sohm took the separation of the spiritual and the secular spheres further by positing that church law stands in contradiction to the nature of the church. For the essence of the church is spiritual, while the essence of law is secular. He was denying any separate right of existence to church law. He argued that the early church had no legal constitution, but was ruled by a power he called charisma. Admittedly, his understanding of law corresponded to that of his time. At that time, law was seen primarily as a coercive order. The dark sides were therefore in the foreground and did not seem appropriate for the church. His criticism triggered several attempts on both the Protestant and Catholic sides to justify the existence of church law. I'm now going to present two Protestant and two Catholic approaches. Let's start with the Protestant ones. The first of these is the approach of Johannes Haeckel. He was a Protestant legal expert. The title of his main work is programmatically Lex Caritatis, Law of Love. He examines Luther's work for statements on canon law and finally arrives at the dualistic concept. His answer to Sohm could be summarized as follows: state and church law are essentially different. He stated, the starting point is the eschatological dualism of Luther's teaching on natural law. A distinction must be made between divine natural law as the legal order of the kingdom of Christ and secular natural law as the supreme legal order of the kingdom of the world. The former was interpreted spiritually by Christ. The latter was given its material legal form by Moses in the Decalogue. Both legal systems have their unity in God's will of law, but it works differently in the two kingdoms. In the kingdom of Christ, as Lex Caritatis Spiritualis, that is law of spiritual love. In the kingdom of the world, as Lex Ira et Mortis, that is law of wrath and death. The bright and dark sides of law could not be contrasted more vividly. The bright sides are assigned to the kingdom of Christ, the dark sides to the world. Haeckel's thesis amounts to a spiritualization and a theological exaltation of church law. Haeckel, however, must assume an autonomous church law on the level of the visible church, which serves the external church regime. It is irrelevant to the Christian condition what this law looks like, and it cannot claim the label of spiritual law, according to Haeckel. In this way, he himself admits that he cannot uphold the thesis of the fundamental difference in the concept of law. The second Protestant approach is the one from Hans Dombois. He too was a Protestant legal expert who used argumentation of legal theology to lay the foundations for an ecumenical church law. His 3-volume major work is entitled Law of Grace, Ecumenical church law. He looked at church law across denominational boundaries and historical epochs, and tried to systematically establish an ecumenical church law. In contrast to Haeckel, he adheres to a uniform concept of law. However, his concept of law remains deliberately vague because he thinks that law cannot be defined. He tries to overcome the contrast between law and grace by deriving law directly from grace. He interprets church law as a complex of processes in which the relationship between God and man is performed directly. He stated, grace is a legal process in which a destroyed legal relationship is restored between two persons or a new one is established. The unilaterally entitled giver, by virtue of his superior legal power, grants the non-entitled person a new foundation or an increase of legal status as a freely given, unconditional favor. The grace requires acceptance by the beneficiary. It is not dependent on the recipient's own performance. However, it obliges the recipient to be grateful in a legal sense. A violation of this obligation would lead to the forfeiture of the benefit. However, the question remains whether grace can be grasped in legal terms at all. Ultimately, this too is a theological exaltation of law. Let us now turn to the Catholic approaches. In Catholic theology, the principle of incarnation is applied to the Church as well. Just as Jesus Christ is both true God and true man, so too in the Church there exists one complex reality which coalesces from a divine and a human element. The Church is therefore not only a spiritual community, which has withdrawn from a legal regime, but also a visible assembly, which, like any human society, needs a legal order. The first Catholic approach I will present is from Hans Barion. He dealt with Sohm's thesis early on. He recognized that a response to Sohm had to start from the concept of church and therefore had to be theological. He stated, creed determines the concept of church, while the concept of church determines church law. Whoever professes Sohm's religious conviction finds it difficult to justify church law. The Catholic must reject Sohm's thoughts and recognize church law from one's own standpoint of faith, not for the sake of legal considerations. Barion links the foundations of canon law to the regime in the Church. He goes on to say, the hierarchy supports church law while being supported by divine law. Ultimately, however, Barion contents himself with the statement that Christ willed the church and endowed it with a legal structure. Such an argument, however, would have been opposed by Sohm himself. To counter Sohm, it would have been necessary to ground canon law in the nature of the church. And this is precisely the attempt that made Klaus Mörsdorf. His theory is the second Catholic approach I'm going to talk about. It is the most important one and is still held by some canonists today. According to Mörsdorf, the nature of the church is exposed in its essential practices, namely in the proclamation of the word of God and in the celebration of the sacraments. According to Mörsdorf, these themselves have a legal character. The proclamation of the word in the church possesses legal character in that it takes place by the authority of the Lord. The legal claim of the proclamation is conveyed by the authorization of the apostles in the Jewish legal form of shaliach. In Jewish law, the representative is called shaliach. he performs an act of legal significance for the benefit of the sender. The Hebrew term is comparable to Greek apostolos, from which the English word apostle comes from. Mersdorf also explains the legal character of the sacraments by means of the legal symbols. The sacrament is not only a symbol of a salvific reality that is invisible in itself, it is also an efficacious symbol. This makes it related to the legal symbol, which has the power to say or effect something that is legally binding. Firstly, several sacraments have immediate legal effects in the Church. Secondly, they require a legal order to ensure their authenticity. The strength of this approach lies in the fact that canon law is truly grounded in the nature of the Church. A weakness, on the other hand, is that the concept of law remains unclear. Law in the Church is not the same as law in the state, according to Mersdorf. For him, canon law is a sacred law that is completely different from secular law. Correcco, a follower of the Mersdorf school, took this approach to an extreme. According to him, canon law is different from state law in the totality of its elements. The difference of canon law is also reflected in the fact that it is less concerned with the virtue of justice than with the virtues of faith, hope, and love. Following Aquinas, the ecclesiastical tradition regarded law as an ordinance of reason. In contrast, Correcco describes canon law, unlike secular law, as an ordinance of faith. He justifies this by saying that reason in our modern culture is detached from any structural connection to faith. According to Correcco, the relationship between the faithful and the hierarchy is fundamentally different from that between the citizen and the state. The autonomy that the citizen needs vis-à-vis the state cannot be applied in the same sense to the relationship between the faithful and the hierarchy, because both are part of the ecclesial communion. Therefore, in cases of dispute, it is more important to avoid litigation. The trial procedure, which is indispensable in a state upholding the rule of law, could be replaced in the Church by other instruments of sacred power. Such a view is very reminiscent of the position of Taoism and Confucianism outlined at the beginning, which desires to avoid litigation in favor of harmony. Now we will move on to some comparative remarks and to some concluding reflections on the dark and bright sides both of law and of religion. The Protestant and the Catholic positions presented in my contribution are very similar to each other in one point. They justify church law theologically. Some of them, especially Haeckel and Mersdorf, go even further by making church law itself a theological reality that is fundamentally different from secular law. This result of the comparison may be surprising, since Catholic and Protestant ecclesiology diverge quite strongly. Certainly, other positions are held in Germany, both in Protestantism and Catholicism, which have been disregarded here, but those mentioned are of particular interest with regard to the bright and dark sides of law. They recognize that law has both sides and find that the dark ones are not appropriate for the Church. As a result, they split the concept of law and develop their own theologically disguised and purified concept for the Church. The emphasis on communion and love runs the risk of spiritualizing the law and overemphasizing harmony in the Church at the expense of freedom and justice. Conflicts arising between the hierarchy and the faithful, which should be resolved precisely through legal proceedings, would easily appear pathological. The scandals of recent years show that the Church itself has dark sides. They are, among other things, a consequence of the disregard for church law and cannot be brightened by sacralizing or spiritualizing the power of governance. On the contrary, in order to shed light on them, the disturbing sides of the law must also be endured: litigation, condemnations, and indemnity. Not only is law something ambivalent, but religion is as well. Law does not darken the nature of the Church. Rather, the Church becomes dark when she disregards the law. Thank you for your attention. It was a pleasure talking to you.
Fantastic. We have the opportunity for questions. I think we can either use the hand below or wave, or if I still ignore you, just start talking. Anyone with a question? Shall I start then to open the floor? The one question I have is, you did mention Islamic law, for example, and the divide between between religion and state that happened very early in terms of Christianity. Why is it so difficult for Muslims, for example, to reach that same conclusion that religion and state should be divided? I know it's not something that you touched upon, but do you have perhaps any views on that?
Yeah, thank you for your question. Of course, I'm not an expert on Muslim law, but I have much contacts with Muslim lawyers, and as far as I see, there are also different approaches and different ways to justify. One point is that Jesus Christ was not a political leader, whereas Muhammad was. Right from the beginning, there was the state in Medina that was not only a spiritual community, but there are also other approaches that say that even in Islam, there is the distinction between religious and profane, religious and secular. Yes, and even a friend of mine who is a Muslim lawyer, he would say what we are calling Islamic law is for a great part not really religious law, but he would call it secular law because it's dealing with secular matters. Yeah, so there are very different approaches and opinions within the community of Muslim lawyers, and yeah, it's I think they are discussing among themselves, and I don't know what conclusion they will reach.
Thank you. Rosalie, I see you have your hand up. Question, please.
Yes, hi. I'm Rosalie Jukir. I'm from Canada, from McGill University. And thank you for your presentation. I wanted to ask you maybe how in Germany or other countries in Europe that you've researched, how this actually plays out in practice, right? Because it's sort of easy to say, oh, religion and the state are divided, so secular courts don't get involved in any religious issues, and, you know, religion is in its own sphere. But we've had some, I don't know if you've known about this, and I'm happy to discuss these with you, but we've had some really interesting cases in Canada. As it happens, a lot of them deal with the Jewish religion and the extent to which the secular courts can intervene when it is an issue of Jewish law. And in particular, it's arisen with respect to religious divorce. So in the Jewish religion, it's the get. Now, of course, a Jewish couple can go and get a civil divorce, but if the religious divorce is not given, there are significant consequences to one of the spouses, the woman, as it happens. It's a very unequal situation from a gender perspective. And the issue is, what can secular courts do if, for instance, one party holds the other, over ransom and says, I'm not giving this religious divorce? To what extent can they use the courts? And as I said, there's been some interesting decisions. We've had a Supreme Court of Canada decision in which the court, although it's a split decision, 7-2, said that because in the corollary relief agreement, the parties actually laid out what they would have agreed to, and it included the husband saying he would give the religious divorce, that could actually be enforced by a secular court. Not specific performance, not to force him to go give the divorce, that wasn't the issue, but rather to pay damages for 15 years of not giving the divorce. So I'm sorry for the long-windedness of this, but we have some other interesting cases as well in Canada. But the divide, just to say, religion and state are divided and secular courts don't get involved, is almost too simplistic a statement, because there are all sorts of these nuances where the courts can, in fact, get involved. And I'm wondering what you think of that and what's happening in that area, maybe in your jurisdiction.
Thank you for your question. The situation is different in Germany. The Constitution of Germany says there is no state church in Germany. However, the separation between church and state is not strict, but there is a system of cooperation between state and not only the two big churches, but also other religious communities. But with regard to marriage law, there is a separation. And in Germany, there's a system of obligatory civil marriage. So in order to be married before the state, only the civil marriage is valid. The state does not recognize religious marriage. And the same thing applies to divorce. Before the state, only the civil divorce is valid. There are, of course, church courts, Catholic church courts in Germany, even Jewish courts in Germany that are working. But with regard to marriage law, their decisions are not recognized by the state. So there's no reason for the state to intervene in Jewish marriages and to enforce the husband to make the get, because anyway, get is not has no legal consequences in civil law, and the couple has, or the wife has to address a civil court to have divorce, and that's it. And the same is true with Catholic sentences on marriage annulment. They are not recognized by the state. However, there are other matters in which the religious courts are recognized by state, even Jewish courts. There is a case even dealt with by the European Court of Human Rights in Strasbourg, which dealt with a German case concerning Jewish court decision, but this was about internal organization matters of the Jewish community, and the court said this is an internal matter of the Jewish community, and state is not. There's no ground for the state. Judgment. State courts are not competent for this. Yes, And with regard to the Catholic Church law, in Germany there's a particularity within labor law, because the churches have their own labor law and also their own courts to judge about labor law regarding the employees of the church. And these judgments are recognized by the state, and the state says the state is not competent to judge these internal matters. But as you know, perhaps this is disputed in the European Court of Justice of the European Union, and there's a case still pending at the Constitutional Court of Germany. Yeah.
Can I ask one tiny follow-up question? I don't mean to monopolize. It was what if two parties enter into a contract which seems valid in every other way? There's consent, there's no defects of consent, there was no coercion, it's a valid contract. And in that contract, one party promises to execute a religious obligation. Would that be enforced in a secular court in Germany?
Yeah, that's a difficult question. If this contract is valid under state law, the state court would regard this contract as a civil contract, and I think they would make a decision.
That was the issue in the Canadian case, right? Just like in Germany, a Canadian court would never come in to compel a religious obligation. And just as in Germany, religious divorce is not enough. You need civil divorce. Yeah. Our religious ceremonies of marriage actually also count as civil. That's very different than in Europe. But divorce, a religious divorce has no effect legally. But these parties actually promised in a contract that they would execute this religious obligation, and still, I mean, opinion is divided, right? Half saying absolutely not, even though it's in a contract. It's against public order for a secular court to enforce a religious obligation that parties agreed to, regardless of if everything else is good in the contract. And the other side says, well, no, let's look at this. If this, as you just said, is a valid civil contract, what's the difference if someone's promising to mow someone's lawn or someone's promising to give do a religious obligation? Anyway, it's an interesting, yeah. Your talk made me think of these things. And again, I'm sorry to monopolize. It's just really interesting.
I have to clarify my answer. And now I know what you are thinking about. I'm not sure if a German court would accept this claim if it is a merely religious obligation. Yeah. Perhaps it would also say it's not competent. In my answer, I thought about contracts about material things and so on. But if it's really a religious obligation, I'm not sure about that. I don't know any cases. Yeah.
Okay, thanks. I'll send you the case in Canada, and I'll let other people.
With pleasure. Yeah, thank you.
Just for interest's sake, I might mention that in South Africa we have the same issue where you get a civil divorce, but they don't want to give a religious divorce. And it was also in the case of a Jewish couple. So what the legislature did is to add a provision to the Divorce Act that says when a religious divorce must also be given, the court can, in its order, a divorce order, make some or other provision that would actually force the husband to give the get. Not a get, any religious divorce. So what happened is that the court would, for example, make a maintenance order and add to that order and say, you will pay maintenance of this amount until you give her the get, the religious divorce. So that is sort of a punitive order to encourage the husband to give the religious divorce. But the court said, well, we cannot force you to give her the religious divorce, but we can give all these extra measures that sort of motivate you to give the religious divorce. So we had the same problem, and that is how the legislature fixed it, is to allow for that. But I have another question to you, if nobody else has a question to anybody else? Good. And that is my university, Potchefstroom University, used to be the Potchefstroom University for Christian Higher Education. And the principles that we used here was Calvin and also Doyeweert. Are you aware of the Doyeweert and his work? He was actually a Dutch legal philosopher, and his idea of how the law works is actually very interesting. So perhaps you can also, because he also links law and religion in his writings, and that could be very interesting for your research as well.
Mm-hmm. Thank you.
Anybody else for a question? I don't think Joseph joined us. I've sent him a few links now, and he hasn't responded to any of that. So I don't think we're going to have another speaker. You can actually ask as many questions as you like to Burkhard. This is your chance. More questions, Rosalie? No. Do you have anything else to say, Burkhard?
I have covered 45 minutes, which was my time. So.
We have an early night while all the other panels are still going on. We can go and have some dinner.
Yes.
Thank you, everyone. Appreciate your time and the questions that you've asked. See you in the next session. Bye.
Thank you.
Bye.
Goodbye.
Bye.